No, we had inspections on 5/20, the COC inspections. There were a number of items that we noted were failing for the inspections. They were supposed to come back out on 5/22 for reinspection. That was what we discussed at the pre-meeting.
Okay, pause right there. We've already got our first red flag. Inspections were scheduled, but no one from the city showed up. That's not just a scheduling hiccup, that's a procedural failure. And in housing court, timing on inspections can be the difference between people living in safe housing or being stuck in limbo. So the question is, who dropped the ball and why?
Property essentially being hacked to collect some items. And then we will be on the 23rd to discuss where we are with COCs. Nobody showed up on the 22nd. We had guys there waiting for the reinspection, ready to go. Nobody from the city showed up to do the reinspection. So that's first and foremost at this point. I'm not sure. We were provided no notice as to why they would not be there on the 22nd. We were expecting that to occur. So our guys are ready with items having been corrected from the original list, from what they noted on the 20th, and nobody from the city showed up on the 22nd.
Anybody know why they didn't show up on the 22nd, Mr. Parker?
Your Honor, the inspector was standing in Carol Kunky's courtroom yesterday with counsel. So he knew exactly why I wasn't there. Because there was a laundry list of non-callbacks that we didn't have. Judge Kunky has entered orders, or will be entering orders, we think, this morning, addressing the repair and inspection protocols for all of these buildings, because she has some jurisdiction over all of those. But we were called back out to say, this is fixed, now look at that, this is fixed, now look at that. We're going to continue to do our inspections, consistent with what we've agreed to do, and consistent with what we've been ordered to do by Judge Kunky.
I was in court. Joe and Myers and Gary Dunham were in court as well. I know that the city has.
Now this is where it gets messy. The city is saying, we're doing what we're supposed to do, but the defense is saying we were left hanging. Meanwhile, the tenants are the ones left sitting in the middle of a bureaucratic ping-pong match. Ever. Notice how nobody wants to claim responsibility, but everyone's holding a piece of the.
As other inspectors, we were expecting an inspection to occur. We had guys ready. We had no reason to know that they were not going to show up. We didn't know Jerry or Joe were going to be in court. I don't know what there was no reason for them not to have showed up. I didn't notice that they weren't going to show up or to not arrange for other inspectors to come to the property to inspect, as we discussed.
All right. So I guess I want to make sure, and maybe I'll touch base with Judge Kunky. Is she issuing an order?
So
laying out everything, because then I don't want to interfere in any of that.
So Judge Kunky is entering an order based on what she explained on the record. She will be entering an order that repairs be done at the property, basically as urgently as possible, get the repairs done. She will be entering an order with regards to tenant requests for relocation, things of that nature. Obviously, we don't know exactly what it's going to say, but this is what she indicated on the record, and as well as instructions to the city for timing of inspection. She took some issues with that, so she's going to require the city to inspect within 2 days of a request, and also make themselves reasonably available for inspections if they're already on site for something, to inspect other work that may be ready. So she's going to be entering orders to that effect.
Do we know when she's going to do that? Or did she?
That we would possibly have a draft of that order at minimum today to see what it would look like. I think she's waiting on 1 or 2 exhibits that ourself and legal services are working on in connection with that. I know I spoke with Lou about it, so I'm not sure.
Yeah, we're working on a draft that we should have over by the end of today, and either today or I think next week she's planning to send out that order based on our draft and possibly yours that you send in, which will be covering what she's dealing with in terms of focusing on repairs, as well as how tenants might be able to get relocation assistance from their escrow amounts with the city, as well as whatever they pay to the landlord since September 17th, so that they can use that towards relocation for the tenants that are still, in the property.
All right, so what I guess I would want to make sure of what's contained in that order, because we have, this court has escrow funds.
Right. So one of the items that will be in the agreement that I think is pretty undisputed at this point is that Arbor One will not object to the release of the escrow that's being held.
And here's the power move. Judge Kunky is about to enter an order that could override the entire process. We're talking tenant relocation, expedited inspections, and even tapping into escrow accounts. This isn't just a legal maneuver, it's a reset button. But it begs the question, how much overlap is too much when two courts start stepping on each other's toes?
By the city or the court. I believe that the city's agreement requires that like all parties agree to some extent, so or something of that nature. So the order will clearly say that if they're electing the remedy to break their lease and move from Arbor One, that we won't object to those funds being released so that they can utilize that in finding whatever housing they may want to find.
Okay, so that will be contained within the order.
Yes, that will be involved with the order. Yes.
Okay. So what it seems like to me, and I guess what I'm going to do is I'm going to pause and I'm going to try to reach out to Judge Kunky directly and just see exactly what she's doing, because if she's going to assume all of this, there's no reason for two courts to be doing it, in my opinion. So
to the extent that there are folks on your docket that have been relocated, so one of the things that she indicated is folks that are being relocated are going to be paying half of their rent. I know that that's something that
paying half of their rent,
or what it would have been in Arbor One. So if folks are being relocated with the intent to come back to Arbor One, so temporarily relocated, basically saying, I want to come back to Arbor One once I can be placed in a building with the COC, those folks are being required to pay half of their rent during their relocation period.
I don't think that was part of this initial order, but she did bring that up as a possible thing she was considering in the future, and bringing up those issues of tenants relocated to the hotels. We did have Mr. McGuire, who was relocated to the hotel, and it seems he's been relocated back to his apartment.
Okay. So I guess I'm curious. So where would, and I realize you don't have the order, where would this half rent be paid?
To Arbor One. And so basically the argument was, if we're relocating folks to a place that has a COC, whether it's, whatever accommodations are ultimately determined, Judge Kunky found it reasonable to say that they should be paying half of their rent. And so I believe that it is going to be in the part of the order. The last part that we talked about, no order, so that there's no direction to relocate folks or something in the order that says folks can request to be relocated but have to pay half their rent. So I believe that she decided that was going to be a part of the order, so it's going to be in there. And I bring it up and I know that this is something we talked about last time with folks that were on your docket having been relocated, establishing whether or not they intend to stay. And at that point, we should be discussing leases with those folks, or if they're planning to come back to the city side. And if that's the case, then they would be subject to that part of the order. So we just wanted to advise the court that would be something that would be happening with those folks.
Okay. Got it. So for individuals, I'm just thinking about the cases that are before me. So for those individuals that relocated coming back,
First place?
they would be, let's say their rent's $1,000. They would have to pay $500 to Arbor One.
Correct.
What happened? Okay. What happens with the other piece?
The other piece of the rent.
Yeah, it's just not paid.
I think that is just taken as a loss to Arbor One. I think the idea is that.
Got it.
Yeah, so it's basically everybody's paying half. That was the.
And I think it'd be specific to their portion as well, too. If they're subsidized, they pay half of their portion, whatever that is.
Got it. They pay half of their portion. What happens with the subsidy?
I don't know if it was fully addressed.
Got it.
That's not something we got into.
Okay.
up to the
Or
tenants.
subsidy counts for hotel.
So I think what I will do, and so I could make this a very short hearing, it seems. Because it seems to me that if she's going to do all of that, that I'm not going to do anything and wait and see how it affects the cases that are before me, with reference. So for example, just taking by way of example, the escrow order, that really, I think in some ways negates the escrow order, right? For those individuals that would fall within that classification. Would you agree with that?
It negates your escrow order.
Yeah, because so if an individual is intending upon coming back, what the circuit court is saying, they need to pay half of their rent to Arbor One and Arbor One West. My order would indicate that they pay nothing, that they pay everything to the court.
Right, so yes, in essence, it would negate that, and then for the folks that are leaving altogether, they would get it back. So yes, in essence.
So of the cases that I have, how do I sort those people out?
For the folks who have been relocated versus, we don't know the extent of everyone's desire to be relocated or staying permanently or temporarily. Some folks have also found their own housing at this point. So I think we would need to just get a list of folks that have been relocated by Arbor One and, connect with them about, to the extent they intend on staying where they are, or if they are intending to come back to the city side. And if they're staying where they are, then we can deal with leases. And if they are intending on coming back to the city side, once there's a unit available that has a COC, then they would be required to pay their 50% of rent.
And do we have any people still in hotels that were relocated to hotels?
It's my understanding nobody is still in a hotel.
Okay,
Everybody's been relocated somewhere else.
I believe Mr. McGuire was relocated back to his original tenancy.
On the
So
city side,
I believe so.
I can inquire into what's going on there. I don't know why it's what's happened there, but inquire and get the court information if that's what you're looking for, Your Honor.
Well, I just want to make sure that the 42 I have, that the orders that are consistent with what's been ordered at the circuit court. That's what I want to make sure of. And I guess we can do that sort of on a continuum basis, or what I could do, and what I may be inclined to do, is to just issue a stay on these proceedings before me and just await the final resolution in circuit
Our next visit with Judge Kunky is on
on the 9th of June.
In lieu of a stay, could we perhaps adjourn proceedings for, say, 3 weeks?
Comes the gavel drop. Judge is talking about issuing a stay. Translation: put this case on pause. With conflicting orders and relocation chaos, that might be the smartest move. But here's the catch. Delays can mean uncertainty for tenants. So, is pausing the right call or just kicking the can down the road?
We can sort everybody out, who's going to do what, when, and where, and then we can maybe get some dismissals or CODs or settlement agreements in place.
Something in place
Yeah.
on these. That's fine with me also.
Okay.
I don't have a problem with that as long as the repairs are being made and the tenants. It sounds like through what Judge Kunky's doing, the tenants are being taken into account in terms of what's happening. So,
I think a stay might work better because I just don't know how long this stuff in circuit court's going to go on for. But I think, once that's over, it's mostly going to resolve any issues that exist for all these tenants in this report, I believe.
well, why don't I do this? Why don't I adjourn it out to the 27th of June at 11? All right. Allow that to kind of take place if necessary, and then do that. All right.
Good. Thank you, Your Honor. In lieu of you having to bring your staff out, on the 28th, I have a pamphlet showing a lot of,
the
Yep.
things. All right.
So what Mr. Whitman is providing is photos taken of units in both of these buildings. At this point, we're dealing with situations where many of these units are ready to go, turnkey, ready. There are remaining items on the correction orders list, but not necessarily because they weren't corrected from the original list, but upon inspection, the city added more items to the list. And so we're obviously, you've made your decision with regards to having Kunky over here. This is, we're going to be arguing that these buildings are ready for the minimum temporary COCs. There's no reason that folks should not be in those units. And a correction order for the units that still have some items that need to be done, list be provided of a 30-day correction order. These units are not to be occupied until corrected, and a temporary COC provided for the building. At this point, we need to get folks in these units that are ready to go.